Judicial Philosophies, Judicial Restraint, Strict Constructionist, and Judicial Activism. Why do we need judicial philosophies? Each judge is different, but each of them at least follows one of the three judicial philosophies, but it all depends on which one follows their own beliefs. Activism, restraint, debate. Advocates argue that courts should allow the decisions of other branches to stand, and when they offend a judge's own principles. Restraints defend their position by asserting that unelected judges make up the federal courts. What does judicial restraint mean? A philosophy of judicial decision making that courts should allow the decision of other branches of government to stand, even when they offend a judge's own principles. Restrained judges are also less willing to overturn the prior judicial decisions. Examples of judicial restraint. One court case that is an example of judicial restraint is Luther v. Borden, which is when the Supreme Court of the United States established a political question doctrine in controversies arising under the Guarantee Clause of Article 4 of the United States Constitution. There are other cases that use judicial restraint, such as Dred Scott v. Sanford, Plessy v. Ferguson. What does strict constitutionist mean? An approach to constitutional interpretation that emphasizes interpreting the Constitution as it was originally written and intended by the farmers. Examples of strict constructionists. An example of a judge who uses strict constructionist is Antonin Scalia. His commitment to originalism, the theory of constitutional interpretation that says judges must apply the original understanding of the constitutional text. What does judicial activism mean? A philosophy of judicial decision-making that judges should use their power broadly to further justice. The judges make decisions based off of their personal or political view rather than the law. Examples of judicial activism. One court case that is an example of judicial activism is Roe v. Wade, because of the decision was based on implied rather than enumerated constitutional right to privacy. There are other cases that have judicial activism, such as Baker v. Carr, District of Columbia v. Heller, Bush v. Gore. References.